The fourth important clause to understand in an asset purchase agreement is the buyer's conditions precedent clause. A condition precedent is a legal term that refers to an event that must occur before the buyer will have to actually close on buying the business. And if the event identified doesn't occur, the buyer doesn't have to buy the business and won't be breaching the agreement by not buying the business. Some of the most common events identified in a buyer's conditions precedent clause are things like, first, if the buyer is seeking financing from a lender, the conditions precedent clause should state that the buyer has received suitable financing from the third party. Second, if the buyer needs to obtain various permits and license in order to operate the business, the conditions precedent clause should state that the buyer has obtained whatever permits and licenses are needed to operate the business. Third, if the buyer needs to obtain a lease from the seller's landlord or get some other important agreement assigned, the conditions precedent clause should state that these agreements have been assigned to the buyer from the appropriate party. And there are lots of other conditions precedent that could be identified in the buyer's condition precedent clause depending on the deal.